We need to talk about something big happening right now in the fight to remove restrictions on gun suppressors and short barrel rifles. The Trump administration's Department of Justice is defending these old laws, even though Congress just changed the tax to $0. And now, several anti-gun cities have joined the fight on the government side. Congress recently passed a massive bill called H.R. 1, also known as the One Big Beautiful Bill. Hidden inside that law was a major change to gun regulations. They reduced the National Firearms Act tax from $200 all the way down to $0. This change takes effect next year. The National Firearms Act is an old law from 1934 that puts special restrictions on certain firearms, things like suppressors, short-barrel rifles, short-barrel shotguns, and other items. For decades, if you wanted to own one of these items, you had to pay a $200 tax, register it with the government, and go through a lengthy approval process. But now that tax is gone. It's $0. Several major gun rights organizations saw an opportunity. If there's no tax anymore, they asked, why should all these other restrictions still exist? Groups like Gun Owners of America, the Firearms Regulatory Accountability Coalition, Silencer Shop, Palmetto State Armory, and Silencer Co. all filed lawsuits. Even 15 states joined together to sue the Bureau of Alcohol, Tobacco, Firearms, and Explosives. They're all saying the same thing: finish the job and remove all the remaining National Firearms Act restrictions. Their argument makes sense on the surface. The original law was passed using Congress's power to collect taxes. But if there's no tax anymore, what gives Congress the right to keep regulating these items? That's the core question in these lawsuits. Here's where things get interesting and maybe disappointing for some gun rights supporters. The Trump Department of Justice, led by Attorney General Pam Bondi, is fighting to keep these restrictions in place. They're arguing that even with the $0 tax, the National Firearms Act is still constitutional and should remain the law of the land. This isn't the first time. The Trump DOJ has consistently defended the National Firearms Act in multiple cases. They've established a clear pattern of supporting these gun regulations. In their legal response, the DOJ makes several arguments. First, they say the law still imposes taxes on gun manufacturers, dealers, and importers. These are called special occupational taxes. According to the DOJ, since some taxes still exist in the law, the entire registration and approval system should stay in place to help enforce those taxes. They describe it as a web of regulations that all work together. In their view, you can't just remove part of it. The registration system, the approval process, the background checks. All of this helps the government enforce the remaining taxes on the gun industry. The DOJ doesn't stop with the tax argument. They pull out another tool from the legal toolbox: the Commerce Clause. The Commerce Clause is part of the Constitution that gives Congress the power to regulate business activity that crosses state lines. The DOJ argues that suppressors, short-barrel rifles, and other National Firearms Act items are manufactured and sold across state lines all the time. This makes them part of interstate commerce. According to their reasoning, Congress has the right to regulate these items at every stage: when they're manufactured, when they're distributed, when dealers sell them, and when individuals buy them. The DOJ believes the Commerce Clause gives Congress this authority, completely separate from any taxing power. They also argue that the restrictions don't violate the Second Amendment right to bear arms. So in their view, the National Firearms Act passes constitutional muster on multiple grounds. Now here's where the plot thickens even more. Several cities known for strict gun control policies asked the court for permission to file what's called an amicus brief. This is a legal document that lets outside parties who aren't directly involved in a case share their opinions with the judge. The court approved their request. Cities like Baltimore, Columbus in Ohio, and Harris County in Texas filed a joint brief supporting the Trump DOJ's position. They're arguing that if the National Firearms Act gets struck down, it would create serious dangers for public safety in their communities. These local governments claim they have a direct stake in how this case turns out. They say Congress labeled these weapons as especially dangerous for a reason. In their view, items like short-barrel shotguns, short-barrel rifles, and suppressors pose unique threats. According to their brief, removing the registration and licensing system would make it much easier for these weapons to circulate without any tracking. They worry about increased criminal use and say their cities would bear the brunt of any problems. The cities position themselves as being on the front lines. If the National Firearms Act falls apart, they argue, their police departments and residents would face the immediate consequences. More untraceable weapons on the streets, more challenges for law enforcement, more threats to public safety. The cities also emphasize how much their police departments rely on the federal registration system. Right now, there's a national database called the National Firearms Registration and Transfer Record. It's maintained by the federal government and tracks every legally owned suppressor, short-barrel rifle, and other National Firearms Act item in the country. Local police work with federal agents all the time. When they're investigating a crime or serving a warrant, they can check this database. It tells them if there might be National Firearms Act items at a location. This gives officers crucial intelligence and helps keep them safe. If the registration requirement disappears, the cities argue, this database would fall apart. Officers would lose access to critical information. They'd have to operate with less knowledge about potential threats. The cities claim this would put police officers at greater risk every single day. The cities don't just talk about safety concerns. They also claim their brief offers important legal analysis that the main parties didn't fully address. They discuss things like historical tradition, looking at whether similar regulations existed in America's past. They talk about severability, whether parts of a law can survive even if other parts get struck down. They argue that previous court decisions don't support throwing out the entire National Firearms Act. Basically, they're trying to give the judge additional legal reasons to keep the law in place, beyond just the public safety arguments. Here's something that should make gun rights supporters take notice. The Trump DOJ now finds itself aligned with some unusual allies. Anti-gun organizations like Everytown for Gun Safety and Giffords Law Center have also filed amicus briefs supporting the government's position. Now these anti-gun cities have joined in too, for an administration that many gun owners supported, expecting strong Second Amendment advocacy. This creates an awkward situation. The Trump Department of Justice is being backed up by some of the most vocal gun control advocates in the country. Both sides have filed motions for summary judgment. This means they're asking the judge to make a decision without going through a full trial. They want the court to rule based on the legal arguments alone. The gun rights organizations argue that without the tax, Congress has no constitutional authority to keep regulating these items. The registration requirements and transfer restrictions go beyond what the Constitution allows. The Trump DOJ and the cities disagree. They argue the law still has valid constitutional foundations through both the taxing power and the Commerce Clause. They also claim public safety concerns justify keeping the regulations in place. A judge will now have to sort through all these arguments and make a decision that could reshape gun regulations across the entire country. This case is about more than just suppressors and short-barrel rifles. It's about the scope of federal power and what happens when Congress removes one justification for a law but tries to keep the law anyway. It's also about whether public safety concerns can justify gun regulations, even when the original constitutional basis for those regulations has been removed. The outcome will affect millions of gun owners and could set precedents for how other gun laws are challenged in the future. We're watching a major legal battle unfold. Gun rights groups are pushing hard to remove these restrictions, arguing the $0 tax eliminated the government's justification for them. The Trump administration is defending the old law on multiple grounds, arguing it still has constitutional support. And now anti-gun cities have joined the fight, warning about public safety disasters if the restrictions disappear. As this case develops and moves forward, the stakes couldn't be higher. The court's decision could either free millions of Americans to own these items without burdensome restrictions, or it could cement federal control over them for years to come. We'll keep watching this case closely and update you as major developments happen. This is one of the most important gun rights cases in years, and its outcome will affect the Second Amendment landscape for generations. The fight continues. Claude is AI and can make mistakes. Please double-check responses.